I have a question about the Sociedad Anónima, the members of it. So we did mention that there's president, treasurer, and secretary. Is there an age restriction? And meaning to say, would I be able to add my children who are under age of 18 to be part of my Sociedad Anónima if we buy like a family property?
Okay, this is a great question, and I could talk a lot about this. Let me make first a difference of two different things. One is to be a shareholder, and the other one is to be a member of the board. Totally different. This means a shareholder, it's the owner of the company. So we can have members of the board, which they are not shareholders, they are not owners. So, for example, I have husband and wife, owners of 50% each of the each one of the shares of the company. Means they are 50-50 owners, and the wife is the president, the husband is the secretary, and then you can have a friend, an employee or whatever as the treasurer, someone else as the fiscal officer or the controller, and they are not owners. So you don't necessarily need to place the children in the board in order to be owners. In order to be owners, needs to be shareholders. Now, in order to be in the board, they need to be 18 or more. In order to be owners of the shares, could be at any age, but you don't want to have people under 18 years old as owners, because if parents pass away, then we need probation of that, and the courts will protect the minors until they are 18, so no one is going to be able to sell the shares or sell the property or whatever. This means that the recommendation is, as shareholders, all the time have someone more than 18. At the board, they need to be more than 18. But also, this brings me to something else. As members of the board, you could have or not power of attorney. The president, according to the law, all the time needs to have power of attorney. It's all the time going to have power of attorney. But you can add power of attorney to the vice president, to the treasurer, to the secretary, you name it. You can choose whatever you want. And the kind of power of attorney could be what we call full power of attorney without limit of sum. Means they could do whatever, sell the property, this and that. Could be full power of attorney limited to X amount. Could be full power of attorney limited to not selling this asset or the other asset of the company. Could be full power of attorney but acting jointly with someone else. Or you can have some other powers like general power of attorney or special power of attorney. So sometimes I've seen and I have recommended, when you have a family, for example, you have husband and wife with full power of attorney without limit of sum. And this is just an example, of course. So any of the two could sell the assets and do whatever. But then you have two of the kids with full power of attorney without limit of sum but acting jointly. Why acting jointly? Because in that way you're protecting mom and dad that the kids are not going to sell the assets. They need to do it together. One of the two cannot do it. So means that, and this could happen both in the SA or in the limited. The only difference is that in the SA, they will be part of the board. In the limited, there will be managers and sub-managers. But you can have all this kind of powers of attorney. In other words, needs to be more than 18.
Okay. So that kind of answers my second question. And just to reiterate, it's common to see on a Sociedad Anónima members where the two owners, let's say that would be president and the treasury, and somebody like a notary would be the secretary. So now if that property was to be sold, it's only the true owners who are, in this case, president and treasurer, would be the signatory on a sales document, and I guess there's no concern about this third party being also part of your Sociedad Anónima. Is that correct?
It's partially correct, yes. The reason because I recommend an LLC is because you don't need other members. So if it is just to say husband and wife, well, just place husband and wife as manager, sub-manager, or manager 1, manager 2, and they're the only ones that will have signatory powers, period. If you have an SA, you can have also president and secretary, just to say something, with power of attorney, with signatory powers, and have someone else that could be an attorney, a friend that you can choose as treasurer or any other member of the board, and also remember the fiscal officer, which have no power of attorney according to the law. But for a very simple purchase of a condo or a house, I will definitely recommend an LLC in order to have only one, 2, or 3 members with power of attorney and forget about a board.
I have a question about the effect on an estate, whether the piece of property is in an LLC or in an SA. From what I understand, an SA, if one dies, the other one's still there on the board and nothing really happens. But on an LLC, what would happen if you say one of the spouses dies, there are stepchildren, there are children from the other side? How do the two affect that situation when you have mixed marriages with stepchildren on both sides?
Okay, we cannot have all the answers because we need to go to specific cases. But let me once more explain. We have 2 options here. SA, or I'm going to call it, as in Costa Rica, SRL, Sociedad Responsabilidad Limitada, Sociedad Anónima. In both, we have shares. And this one is called shares. And I'm going to just make it like this. Let's say 2 shares. And this one in Costa Rica is called cuotas or quotes. We can translate it as shares as well. And let's say we have 2 shares. Now we have a company, okay, with the name X, SA, and Y, SA. Okay, that will be the names of the companies. With this company, they're going to purchase a piece of land. They're going to purchase a property, let's say a little house. Okay? Now, we have here 2 shareholders. Okay? Just as an example, could be 1, could be 5, it doesn't matter. Shareholders. Now, in this one, we need a board. BOD. Board of Directors. With president, secretary, treasurer, fiscal officer, and plus, you can add more members. In this one, you can have only managers. We're going to call it manager. And you can have 1 or more. So, let's say in this case, we're going to have manager 1 and manager 2. Also, with powers of attorney. Full power of attorney without limit of sum. Okay? Now, the reason of buying with a corporation is basically that if one of the officers pass away and you have another officer, this officer could continue, could sell the property, could continue using the house without a problem. If you have it under your family name, immediately you need to probate in your home country and then in Costa Rica. So having the corporation, you don't need to do it. Now, if you have here, for example, the president and the secretary with full power of attorney, without limit of sum, acting individually, and this one passes away, well, the secretary could continue working and selling and doing whatever. Same thing happen if you have here 2 managers. Problem would be if you only have 1 officer and this officer passes away. Problem, but I'm quoting the problem because you have shareholders. So the shareholders will call or summon a meeting and appoint a new president or a new manager and just continue. means the property here does not need to be probated because it's owned by a corporation.
What's probated in Spanish?
In Spanish, probate is probate
That's
means proceso sucesorio.
Okay.
Okay, you need to go to court, and the court will say who will inherit
So
the property.
probated, English, probate.
Probate in
Probate.
English means proceso sucesorio in Spanish. So the big question, more than who is the owner of this, that we already know that in this case is YSRL, or in this one is XSA, is who's the owner of the shares? That is the big question. And what happens is that sometimes what foreigners will do is to have as owners of the shares their company back at home, or will create a trust for the shares in such a way that if they pass away, they are not really the owners, is the trust. Okay? But if you have all kind of people in that family and step this and step the other, we need to estate plan this. What I'm trying to say is this is a way of purchasing real estate in Costa Rica. Now, it will be totally different to make estate planning and how do you want to solve your problems in case you pass away, or solve the problems of the people that stays without going into probation process back home and in Costa Rica. And the way of doing it is by estate planning, and which most probably what would be the way is through a trust in Costa Rica.
I have a question about the SRL. As far as I didn't know much about it in Costa Rica, so if somebody wants to do business under this sort of corporation, can they do it like a small business?
Absolutely. Yes, it's created for businesses, but it was created thinking in small businesses, not a big hotel, but a small restaurant, or for renting a place, or a small store. I mean, something small, more family or small businesses.
Okay, now saying that if somebody is buying a small property, a small condominium, and they might be thinking in the future doing a small business in Costa Rica, so my customer comes to me and say, I'm going to do a little business, so they can operate that business under that corporation and do everything the same, accounting and everything, right? Yes. Okay. And I had another question, but that was what you asked. So thank you.
I had a question regarding a potential investor coming in with a foreign company, foreign corporation into the country, as far as what the timeline would be, what to expect, extra, money they would have to spend, that type of thing. Just briefly, just to understand.
Yes, Nani. What they need is to bring the corporation needs to go into. They need to have a meeting in their home country and authorize the company to be registered in Costa Rica. Once that is done, they need to come to a notary public, and I'm going later to explain some differences between attorneys and notaries, and record that in the public registry. And it will give an ID number is going to be given. And the cost will depend on the capital stock of the foreigner corporation. So the answer is yes, that could be done. Now, if you ask me, what do you prefer to do, and I've done this several times with different investors, is that we create a company here. Usually, if it is a big investment, it will be an SA. And we do it, and the holding, the company overseas will be the owner of that company, in such a way that you have a Costa Rican company here, working here according to the laws, instead of bringing a foreign corporation. But both could be done. I cannot give you the costs at this point because we need to calculate it. It is based on the capital stock of the company.
Thank you. Just a simple question. I would like to know if someone can create a corporation and buy the property at the same time? Or do they have to wait until the public registry registered it?
Yes, in this case, we would need to, even though several acts could be done with a notary at the same time, in this specific case, we need the person to exist. What I'm trying to say is if the company does not exist, there is no person purchasing. So we need to create the company and then we can purchase. Now, nowadays, to create a company in Costa Rica takes, if it's a long time because there's mistakes and this and that, 72 hours. If it is more or less, some little mistakes will be 48 hours. And if there's no mistakes, in 24 hours, the company is created. So it's pretty much simple to be done. Any other question?
Okay, I have to go back to that one. Thank you. Now, because I didn't know much about that SRL thing. Now, why would I recommend, I already know what each one of them do, but why would I recommend this to a client if they're just simple one-on-one, a small condo in Costa Rica or a house, whatever, and let's say just simple, they don't want to have any business, just that. Why would I recommend this better than this?
The duties of this one, of an SA, and the duties of the SRL are exactly the same, number one. The costs of creating one and the other one, it's exactly the same. So the main difference for a foreigner, just think on a foreigner coming to a new country, they don't know how it works. In my opinion, it's better this one because you only need one officer, at least one officer, and you can have two. In this one, they need to begin telling me 4 names. 4 names, no less than that, could be more. So for example, if it's a couple coming and they want to have their 2 kids in the board, as the example we were given, then we will need to have president, vice president, secretary, treasurer, and they still need to find someone else as the fiscal officer or controller. In this one, someone could come, create the company. I'm the only manager. I'm single. I could buy. I'm the only manager. Done deal. Oh, I'm married. Okay, I'm going to have manager and sub-manager, my wife, and I will be the officers. But there is something else that is important to be said here. But it's only, and at least I could only tell you very slight in regard to the U.S. laws. Okay? According to the U.S. law, if you have an LLC, which is an SRL in Costa Rica, you can have that as part of your assets and make all your tax returns and including your U.S. tax returns, all the expenses that you have in the LLC. If you have an SA, because it's a partnership corporation, you cannot do it. Okay? Only in this one. Now, if any U.S. citizen, and this example is only for U.S. citizens, I don't know the rest of the countries, but for U.S. citizens, if you have more than 10% of shares in this one, or in this one, you also need to declare this in your tax returns in the United States. But the main point on this one is all the expenses are part of your expenses in the United States, not this one. So that will be another reason for having an LLC if it is a U.S. citizen. But it's just because it's easier to manage than this one. People-wise, how many people do you need in the board? That's it. But if they feel more comfortable with an SA, it's just one more book, same costs, same duties, same taxes.
Thank you so much.
Thank you. So when you talk about the size of the company, and LLC is better for the small condo, just a couple owning it, versus SA for a bigger business, are we talking about corporate shield and a potential liability that might come down the road and where you want to protect yourself? And what is the difference here, LLC versus SA? If somebody came onto my property and broke their leg, am I liable? And is LLC a good protection in this case?
Okay, I will prefer to have this kind of things, this liability for this kind of stuff in a separate section. But in any case, just to answer, liability is exactly the same in one or the other one. It's just that here we have less officers than here. And we want to make things easy for our clients. That's it.
Second question I have, I guess, protection of privacy. If a big investor wanted to do business in Costa Rica, yeah, I noticed that either SA or LLC, you do need to give out names, and it's all in the Registro Nacional that you can pull that up. In the United States, you are able to kind of wrap a corporation into a corporation and then into another corporation where it would be much harder for somebody to lift that corporate shield to find out who actually is behind the corporation to protect themselves if they're doing business on a larger scale.
Obviously, we would need to go case by case and have the potential buyer here to explain what is better according to their needs. But it's important to know this. As shareholders, either companies, doesn't matter if it is this one or this one, the only shareholders that are registered in the National Registry in Costa Rica are the founders. Means that the two first shareholders. Those are the only ones that, as far as of today, are registered or are known. Means that if I create the company as a shareholder with Y, just my name and Y will be registered. Then I could sell, and that transfer of shares is not registered at the public registry, only at what I already call the private shareholders registry book, which is a book in the hands of the corporation. It's not public. So how to get to know who the shareholders are at a certain point? As far as of today, only if a judge asks for that. Okay? Now, the officers are all the time registered at the public registry. That is different. So if you don't want your name to be at the public registry, you cannot be an officer, which is totally different. Okay? Now, it's important to say that there are some bills at Congress that are trying to have a registry, a public registry of shareholders. That has not been approved yet, but it's a bill and it's in discussion. So if you don't want your name, what you do is that we create the company with A and B, and then we transfer the shares to the real shareholders. But the officers are all the time going to be registered at the public registry. Now, who could be the shareholder? Not necessarily needs to be what we call a physical person or the investor. Well, as I was saying, you can have a foreigner corporation, or you can have a Costa Rican holding, and then you can also have the holding owned by a foreigner corporation, and that one by someone else in a trust, and you can complicate this as much as you want. But it will depend on how do you want to plan that, and there is estate planning for that.